Hey, today I'm going to answer the question, how do I protect my idea without getting a patent? I'm JD Houvener, owner, founder, and patent attorney here at Bold Patents Law Firm. I'm also the author of Bold Ideas, The Inventor's Guide to Patents. I've helped hundreds of inventors over the years acquire almost 500 patents as of today. I'm going to talk about this question because it's important to know you don't actually have to go down the patent route right away. There are ways to protect your idea before you go to market or before it goes public. So the first way, which is the most obvious way, is to not tell anyone, right? To keep it to yourself and to make sure you maybe are working through iterations, you're still prototyping it in-house, and to make sure that you're, fleshing it out or getting to the final product, tweaking it, adjusting the invention to when you're finally ready to file your patent application. We work with inventors a lot when they're in this iteration stage, the ideation, or even the conceptual phase, before they're ready to even do a professional search or to move forward with the application. And so protecting your idea at that point is very important. And so do not share it publicly, right? Maintain confidentiality. If you must speak with another third party, I would highly encourage you to use a non-disclosure agreement, also a confidentiality agreement. I would encourage you to hire an attorney to draft that to make sure that it's going to be written and enforceable in a way that you can bank on, right? Count on. If the other party does decide to breach, you'll have a local authority, a local jurisdiction that'll be able to enforce that breach of contract. So yeah, keeping it to yourself, keeping it confidential, those are the primary ways to keep an idea secure without moving forward with patents at that time. Now, as you head into commerce, it does get trickier. If you're going to be selling your product, the major issue to point out here is that you've only got a limited time, up to 1 year from your date of publication or date of sale, before you're no longer eligible to file a patent application here in the US. And so that short amount of time is important that if you're going to go to market first without filing a patent, you only have a very small window. You want to make sure you work with a patent attorney to help make sure you're not going to fall short of that time period, because it is a statutory bar to application eligibility. The third thing to mention here is if you're going to be keeping things secret, there is a doctrine of trade secrets, and you can keep information, know-how, knowledge, really any information that is not readily known in the public that would be valuable, right? Would be valuable to a competitor, and you're making efforts to keep it secret, either through code words, passwords, limited access to your employees. Only some of these research and development employees will have access to it. That's a trade secret, and you should be labeling those documents, certainly if they're physical or if they're digital, with proprietary or trade secret, and that information will stay within your company. And your goal is to enforce that, right? To keep employees as they come and go, to make sure that it's confidential and stays with your company. And the only reason why I would say trade secrets is an option is there's some technologies, right? Some valuable products, some things you can do where even once they're sold to the product, sold to the market, the consumer and even someone, a competitor to you, will not be able to reverse engineer it. So if your competitors, right, as smart as they are, if they buy your product off the shelf, if they won't be able to reverse engineer and find out how you made it, that process, that method to make it could be kept as a trade secret. And it's a great way to protect your inventions, protect your innovations, if you're not going to proceed with the patent route. Know that you are taking a big risk, though. If one of those competitors decides, if they independently come up with the same method and process you do, and they file a patent on it, you lose the ability to enforce your trade secret against misappropriators. And so you've missed your opportunity because you didn't jump on it. Well, hope this has been educational. Bottom line, I do want you to know that the number one way to protect your ideas is with US patent law. It's been around for 200, 300 years, and I highly encourage you to give it the patent attorney and find out more. Click below to find out the Bold Inventors Kit. This is a kit for you to get to full access to my book, also get access to the patent searching, patent application drafting options for you, and get more information, get educated about this invention process. So when you're ready, after you've done that internal ideation and conceptualization to where you're ready to move forward with this product, get a hold of us and we'll be happy to help you. I am JD Houvener. Hope you had a good rest of your, hope you have a great rest of your day. Go big, go bold.